and as Roxana said, I am going to attempt to make a legal process interesting and comprehensible. The Rios Montt trial, I think, is not one that is difficult to make interesting, though at times it has seemed difficult to make comprehensible. And I think now, after the judgment from last night, is definitely one of those times. So if this panel was 24 hours ago, I think it would have been more laudatory, even if still cautiously so, and even if Helen would have called us all into check if it were too laudatory. And I'm going to give a little bit of background. Some of you will be very familiar with this, so bear with me, but just want to make sure everyone is on the same page. Jose Efrain Rios Montt was the de facto head of state in Guatemala for 17 months in 1982 and 1983, coming to power as a result of a military coup and leaving by the same route. On May 10th, 10 days ago, he was convicted of genocide and crimes against humanity for his role in the massacres, forced displacement, rape, and torture of members of Guatemala's Maya Shield population under his rule. This was a historic conviction, the first conviction of a former head of state for genocide in a domestic rather than an international court. On Friday, this past Friday, a week after the verdict, the three-judge trial court under presiding judge Yasmin Barrios issued a 718-page judgment laying out the foundation for the court's verdict, based on the testimony of over 90 witnesses as well as forensic, military, and sociological experts and documents, video, and other evidence. His then head of military intelligence, Mauricio Rodriguez Sanchez, was tried alongside him but acquitted on the same day on the ground that he did not have command authority. But this event is taking place on Tuesday, not Monday, and no human rights trial is over until it's really well and truly over. Last night, the Guatemalan Constitutional Court overturned the verdict and in a 3-2 ruling set the trial back to where it was on April 19th. Helen will also tell us that in Guatemala, with Guatemala's judicial and political realities the way that they are, the fact that the conviction of a former head of state is now null was always the more likely outcome, and the fact of his conviction was the more unlikely one. Many in this room will know that the period in which Rios Montt ruled was the bloodiest period of Guatemala's 36-year civil war. According to the UN-mandated Truth Commission, more than 200,000 died or were forcibly disappeared during the conflict, over 80% from Mayan indigenous populations. State security personnel and paramilitaries were responsible for 93% of the violations, according to the Truth Commission, and nearly half of all reported violations occurred during one of the 36 years of the war, 1982, the year in which Rios Montt came to power. The trial took place and may again take place in a Guatemalan criminal court more than 30 years after the crimes. It also took place, and maybe will still take place, under a president who was a former head of military intelligence and a commander in a region at the heart of the 1982 and 1983 massacres, and in a country where the military continues to wield significant power. So how did we get to the current stage, and where will things go from here? There were numerous amnesties issued during the war, but laws passed in 1996 and 1997 repealed all prior amnesty laws and provided only for a partial amnesty. So the post-war legal system explicitly excluded from the amnesty genocide, torture, forced disappearance, and other international crimes. A 1999 UN-sponsored Truth Commission initially laid the basis for the genocide claim, finding that, quote, acts of genocide occurred. And two querellantes, the Justice and Reconciliation Association, Asociación Justicia y Reconciliación, or AJR, alongside CALDH, which is the Center for Human Rights Legal Action, brought the case to the public ministry in 2001. Marcy described the important restructuring of the judiciary and the public ministry over the past decade that helped to facilitate and even allow the prosecution of these crimes. But as Marcy mentioned, it was really only about 5 years ago that Guatemalan prosecutors began to prosecute international crimes from Guatemala's civil war, beginning with some successful prosecutions of low-level soldiers, police, and paramilitaries. With continued pressure from the querellantes, highlighted well by Marcy, new leadership at the public ministry, these important judicial reforms, and pressure from international processes, as Kate described, the genocide case that sat stalled for a decade began to move in 2011. Rios Montt himself was indicted in 2012 after his congressional term ended. Bear in mind, he was serving as a member of Congress after these crimes, and he lost congressional immunity. He voluntarily appeared before the court and was placed under house arrest at the time. Early this year, a pretrial judge recognized that there was sufficient evidence to allow this case, a major case against high-level intellectual authors of the worst crimes, or alleged high-level intellectual authors of the worst crimes, to proceed. And the starting date for the trial was set for March 19th. 30 years after the crimes, 13 years after the filing of the case, the trial date was officially set. The trial moved steadily, painstakingly, and I would say heartbreakingly for the first 20 days of hearings, with horrific accounts by more than 90 survivors. Witness after witness described military incursions on their villages, indiscriminate massacres, rape and torture, and forced dislocation into the mountains where victims faced starvation and military bombing campaigns. Experts testified about, amongst other things, mass graves uncovered, including of women and children, statistical evidence that demonstrated a wildly disproportionate rate of military killings of Ixiles as compared to Ladinos, and a military chain of command which would ensure that the military head of state had both knowledge and legal authority. Then things grew more complicated. After the defense presented a few witnesses and delayed and obstructed as the trial moved towards its anticipated closure. On the verge of the tribunal's exhaustion with defense delaying tactics, the defense attorneys walked out in protest and against very strongly stated orders of the judge. Between then and the eventual May 10th verdict, the trial was suspended temporarily 3 times. First, from April 19th through April 30th, after the convergence of factors, the aforementioned defense attorney walkout, the decision of a pre-trial judge, Carol Patricia Flores, who may have been the one that was referenced subtly or not so subtly by Marcy in the previous panel, in the previous presentation, to order the entire trial annulled and set back 17 months before either Rios Montt or Rodriguez Sanchez were actually even indicted in the case, and a decision by an appeals court that certain due process issues must be fully heard and the trial suspended until they are fully heard. A little complicated, but that is the most relevant thing for the judgment from last night from the Constitutional Court. Again, on May 3rd through 7th, to allow the incorporation of a new public defender when Rodriguez Sanchez's attorneys did not reappear after their walkout. And then again on May 8th, when Rios Montt's attorney did not appear in court due to an illness that the court would later learn prevented him from attending hearings but not from visiting the public ministry after surveillance video was introduced on the same day. So it was virtually on the eve of closing arguments, but there was increasing skepticism that the trial would ever be permitted to conclude. Despite these continued challenges, the trial court eventually concluded, and on the afternoon of May 10th, in a packed courtroom, the trial court handed down its judgment. Rios Montt was found guilty of genocide and crimes against humanity and sentenced to 80 years in prison. The court found the testimony proved beyond a reasonable doubt that under Rios Montt's command, the Guatemalan armed forces elaborated and implemented a series of plans designed to eliminate the Maya Ixil population as a group, since they considered the Ixil supported the guerrillas. The court also found that Rios Montt authorized the military operational plans and actively developed the national security plan, which resulted in the massacres, forced displacement, and other crimes. The court found that Rios Montt had full knowledge of what was happening and did nothing to stop it, despite having the power and capacity to do so. One of the elements of genocide is an intent to destroy, in whole or in part, a national, ethnic, racial, or religious group. The court found that the crimes were not spontaneous acts, but the Guatemalan army intended to eliminate the Maya Ixil as an ethnic group, in large part due to racism. The military operational plans presented into evidence outlined efforts to systematically attack the Maya Ixil, who were perceived to be rebellious, difficult to control, and the social base of the guerrilla. The tribunal made reference to the military operational plans, the forensic evidence, and the statistical evidence, which showed that 5.5% of the Ixil population had been killed during the period in question, with the Ixil killed at a rate 8 times higher than that of the Ladino population. On the other hand, the court found that as Director of Intelligence, Rodriguez Sanchez did not have command responsibility, and that his responsibility for and involvement in the crimes had not been sufficiently established. And then, after an apparent attempt by Rios Montt's attorney to whisk him out of the side door, Rios Montt's house arrest was revoked, and he was transported immediately to prison where he would stay for the weekend. It seemed to many survivors and human rights defenders on that day that there might be room in Guatemala for accountability, and even for the most powerful, and despite tremendous political complications. So what happened yesterday, only 10 days after the verdict, and what does it mean? Should clarify that Rios Montt, after a weekend, was transported to a hospital where he is undergoing medical tests and residing probably now to return to house arrest given the turn of events that we've seen yesterday, at least for now. The judgment is less than 24 hours old and certainly will play out in the days ahead in anticipated and unanticipated ways. So this is only a first account, but one that presents major challenges for the culmination of a trial that seemed, at least initially, concluded only a week ago. The Constitutional Court, in its judgment last night, overturned the 10-day-old verdict and annulled the final days of the trial, sending the trial back to where it was on April 19th. On April 19th, the tribunal had heard all of the prosecution witnesses, but still awaited the presentation of some of the defense witnesses, closing arguments, and of course, the final verdict and sentence. The Constitutional Court also ordered the official suspension of the trial to allow for the full resolution of certain legal challenges raised by the defense, specifically the issue of whether there are legitimate grounds for the disqualification of two of the three trial court judges, an issue that had been presented by Rios Montt's defense attorney on the first day of the trial and had been procedurally rejected but not substantively considered before then. Substantively considered later, but according to the Constitutional Court's judgments yesterday, not fully substantively considered by the appellate mechanisms. At least for now, the Constitutional Court ordered the same trial court reconvene to consider the case. It gave the tribunal 24 hours to comply with these orders or risk dismissal from their posts and the possibility of civil or criminal sanction. The Constitutional Court's judgment was based on a complicated turn of events, which I won't go into in great detail unless people want to know, but you can ask in the Q&A, but also I can point you to our trial monitoring site if you don't know it yet, which is riosmont-trial.org, which has more detail than you probably ever wanted about this. Essentially, an appeals court previously ordered the trial court to suspend the trial and hear complaints that the judge should be recused. The trial court claimed that it had done so, and actually on the eve of the verdict, the appeals court that had issued that order also issued a judgment saying that the trial court had adhered to the judgment, but the Constitutional Court rejected that finding of the appeals court and ordered the trial suspended and that issue fully considered. So that's what the judgment says on its face, but the reality may be a different story. The Constitutional Court judgment in some ways leaves more questions than answers. In its judgment, the Constitutional Court did not explicitly acknowledge that the trial had already completed, concluding with a conviction. The Constitutional Court's judgment may make it much more difficult to get back to closing arguments and any final judgment, whatever that judgment would be. It opens up room for far more procedural challenges. The amparos that Viviana described as recognized by the Inter-American Court as having been used quite abusively in Guatemala to prevent substantive rulings on historic human rights cases. It also opens up the possibility of arguments for the disqualification of some or all of the judges in the tribunal. And if there's a new tribunal that is constituted, it opens up the possibility of the rejection of even more of the trial or potentially a full retrial. So lots of questions at this point. And then there are obviously questions about why the Constitutional Court made this decision. There was always an appeals process for the verdict, but the Constitutional Court intervened outside of this context and before the appeals process could take its course. Importantly, there are two strong dissenting views from within the 5-member Constitutional Court. Judge Chacon highlighted this concern about the Constitutional Court exercising jurisdiction appropriately, saying that the Constitutional Court was improperly ruling on a matter that was ordinary and not concerning constitutional issues. Particularly in light of the fact that a judgment had already been issued, Judge Chacon found that the Constitutional Court's ruling was a disproportionate remedy for a challenge that could have been heard through normal channels, the Apelación Especial in Guatemala. Judge Porras, in her dissent, argued that the court's decision left the victims' rights unprotected and did not consider them at all. Yesterday's judgment provided a legal justification for the rejection of a groundbreaking verdict, but some have also highlighted the political factors inherent in this legal decision. They have pointed to the increasingly forceful messages from military and business interests in Guatemala as primary factors leading to yesterday's judgment. These messages were explicitly intended to influence directly the Constitutional Court and the political powers in Guatemala. For instance, CACIF, which I think has probably been mentioned a couple of times already, and is Guatemala's powerful business association, launched a major public relations campaign following the verdict, asserting that the genocide conviction tarnishes not just Rios Montt, but all Guatemalans who would be considered for now and forevermore on par with the Nazis. And CACIF called for the verdict to be overturned and for Guatemalans to take on as, quote, the mother of all battles, future judicial appointments and the nomination of the next Attorney General in Guatemala. So a case that was touted as a triumph for the domestic prosecution of international crimes is currently in something of a state of tumult. Rios Montt's defense team has in some ways demonstrated that confusion and obfuscation can be a viable legal and political strategy, defense strategy. But as stated in the beginning, and as evidenced from last night, it's not over until it's over. The Guatemalans in the room and those following accountability efforts in Guatemala over the years certainly know this well. While the verdict was never the end of the process, the rejection of the verdict by Guatemala's highest court is also not the end of the process. Kate highlighted that truth and justice are complementary. There's not a choice between one or the other. And the advances in truth-telling here are significant, and no matter what happens, cannot be annulled. Survivors told their stories in a courtroom. The trial opened up or reopened a national conversation about crimes committed against the indigenous population in Guatemala and racism in Guatemala 30 years ago and today. And a trial court issued a very detailed verdict elaborating the crimes and laying the legal foundation for these crimes based on extensive evidence. But with the verdict overturned in a process in disarray, the effort to seek accountability for these and related crimes is still far from over. It's a significant, obviously, for this trial and this process, but also for the recognition of the rule of law in Guatemala, including for heinous crimes committed and protected by the most powerful.